unconstitutional airport searches, government refusing to pay damages, and SWAT raiding the wrong house. All that and more on today's IJ Update. I'm Janae Wilkerson, and I'm here to tell you about the Institute for Justice's new videos, updates and victories, and, most importantly, respond to comments and questions from past videos. Everything mentioned today will be linked in the description. So let's get into it. Did you know that DEA agents unconstitutionally intimidate flyers as they board flights and ask to search carry-on items? We also found that the DEA gets a notice every time a passenger books a one-way flight. Even though the interactions are supposed to be consensual, flyers often get the impression that they have no choice but to submit to a search. We recently released a video that showed the most complete video we've ever seen of this high-pressure badgering. It's received over 2 million views, and we had a ton of comments and questions. The Quicksilver writes, "Thank you for exposing this blatant violation of our rights." And the Aviationist said, "Thank you, IJ, for doing your difficult and extraordinarily necessary work for our country. You are critical to maintaining a free, democratic republic." At Drink Beer says, "The scariest part of this, the guy whose rights were violated feels as though he needs to hide his identity because of potential repercussions for sharing his story." We also had a lot of confusion about what a flyer's rights are when this kind of thing happens. One commenter said, "Well, at the airport you don't have to consent for a search." And another commenter asked, "What authority does the DEA have to randomly search people's personal belongings without probable cause?" So I looked into it and asked IJ Senior Attorney Dan Alvin.
DEA has no authority to randomly search people's belongings without probable cause. Unlike TSA, which can search anyone entering the secured area of an airport to ensure airport security, DEA must obtain actual consent from travelers to search their belongings.
IJ currently has a class action lawsuit against the DEA and TSA over their unconstitutional searches and seizures at US airports. The lawsuit was filed in 2020, and it represents plaintiffs who had cash seized at airports without probable cause. Giant, possibly game-changing lawsuits like this take a long time. Right now, we're navigating the discovery process as we uncover the internal policies and the true scope of these agencies' scheme. After purchasing a mobile home community and fixing it up for a year, Melissa Robinson's American dream turned into a nightmare. After discovering a loud construction crew on her property, she found out they were digging a trench for a new city sewer line. The problem is, they hit power lines and other utilities, causing over $70,000 in damage, and the city refused to pay. Melissa sued, and she won when the state Supreme Court acknowledged she was owed tens of thousands of dollars in compensation. The problem? The city still refuses to pay, treating it like an unenforceable IOU.
It's been a long journey. We have fought this battle for over 15 years. We've paid everything out of our pocket for all the repairs, all the things that we needed to have done for legal purposes.
The Fifth Amendment says that when the government takes your property, they must pay you just compensation. That's a principle that dates back over 800 years to the Magna Carta. And it means that if the government takes your property, they must pay you with money. If you want to learn more about Melissa's case, you can watch the video linked below. On to the comments section. At Anthony Bennett, Kentucky says, "Lack of accountability is the single biggest problem in this country. From the federal government, politicians, judges, law enforcement, bureaucrats, and the local versions of the same, they are rarely held to account for their intentional and unintentional deeds and words." Another commenter said, "Rules for thee, but not for me." At Constitution 1789 says, "She already won. What else can she do if they won't pay?" Terrifying situation. At Burnett Hopkins says, "What recourse does she have? If it was a private entity, she could seize their property or place liens on the property. Can she do this with a municipality?" To answer those questions, here's IJ Senior Attorney Bob McNamara.
So those are great questions, and that's actually why this case is so important, because it's not totally clear what happens when a court orders the government to obey the Constitution and the government just kind of says no. And so that's why we filed this case. We want to establish that in these circumstances where the government takes things and says it won't pay, that you're entitled to a federal court judgment, and you're entitled to have that judgment enforced to make the government meet its obligations under the Fifth Amendment. Now, does that mean we're going to end up with a lien on City Hall? Stay tuned, but we'll see what happens next.
In the dead of night, a heavily armed SWAT team stormed the home in which the innocent Karen Jimerson was getting ready for bed while her loved one slept. They raided the wrong house.
I was in a state of mind of what was going on, what is going on. I'm not a criminal or anything, and I'm thinking, well, this can't be real. How can you mistaken our house for someone else's house? And they stated that they had been watching our house for a period of time, and they just mistaken it for someone else's house.
Although Lieutenant Mike Lewis later reported that he believed the numbers on Karen's home, 593, matched the address on the warrant, 573, Lewis admitted that he never got a good look at her address before ordering the raid. Even worse, Karen's home and the target house looked very different. Karen's house has an impossible-to-miss wheelchair ramp, while the target house had a perimeter fence, a porch, a detached garage, and stairs leading to the front door, which Karen's house lacked. Despite all that, on Lewis's command, officers busted down Karen's door, detonated a flashbang grenade in her front yard, shattered her windows, and held her terrified family at gunpoint until another officer realized Lewis's mistake. In the wake of the raid, an internal investigation found that Lewis completely overlooked the WPD's reasonable and normal protocol, and Lewis was suspended without pay for 2 days. Still, when Karen sued Lewis for violating their Fourth Amendment rights, a panel of 3 judges in the Fifth Circuit ruled that qualified immunity shields him from accountability. The panel's decision defies common sense and binding precedent, so Karen and her family teamed up with us to ask the full Fifth Circuit to rehear their case. Don't forget to watch the video linked below. We had some great comments. At Cape Cod Bob says, "What a sweet woman." And the Super Dingoes said, "I'm so sick of hearing stories like this. Pizza delivery drivers do more due diligence than this to make sure the address is correct." At Talokrum said, "There's a difference between an officer making an understandable judgment error under extreme duress and an officer who displays gross incompetence and negligence in cold blood. Qualified immunity was intended for the first scenario, not for this." At Trevin says, "Qualified immunity is vital to law enforcement. I don't know the details of this case beyond your one-sided video. I imagine that the city and department attempted to settle the case prior to the ruling on qualified immunity, but maybe not. If the police don't have qualified immunity, then the risk of them doing their jobs becomes so great that they'll second-guess whatever they do and lead to inaction, especially when a split-second decision is needed, and the risk of the safety of the public as a whole. Don't you guys think these things out before you post your videos?" At Traven, I asked Patrick Giacomo, one of the leaders of our project on immunity and accountability, to respond to your question.
Hey, thanks for your question. So I think 2 things here. Police should never be concerned about making reasonable mistakes, not because of qualified immunity, but because the Fourth Amendment itself only prohibits unreasonable actions. So the policy that a lot of people think qualified immunity is enforcing is actually something that the Constitution enforces. Qualified immunity often actually gets in the way. And the other reason why police should not be concerned and need to hesitate every time they want to act on the street is because even if you can get past qualified immunity and the merits of a claim and get to damages, 99.98% of the time, those are paid by the government itself, not individual officers. Thanks.
Did you know IJ represents ordinary people free of charge as they fight back against government abuse? If you're looking for a rewarding way to support our work, consider becoming a member of our merry band of monthly donors and stand shoulder to shoulder with IJ's clients every month of the year. Monthly donations are convenient and cost efficient, meaning more of your money goes directly to our fight for freedom and justice. Sign up to donate today at ij.org/monthly.
Detroit routinely seizes vehicles on thin pretenses, and then holds them until the owner can pay a redemption fee, starting at $900. If the owner doesn't pay, the property is forfeited and sold, with the proceeds going to the county. Our client Stephanie Wilson's car was seized for a violation of Michigan's law against using a vehicle to transport illegal drugs for the purpose of sale or receipt, even though Stephanie merely gave her ex-boyfriend who struggled with addiction a ride. She doesn't do drugs, and no drugs were found in her car. The Michigan Supreme Court recently ruled that the government can only pursue civil forfeiture under the state's forfeiture laws if it can show that a car was used to transport drugs for drug trafficking. Only after 2 years of litigation trying to plead her innocence, Stephanie and IJ were able to get her car back. IJ attorney Kirby Thomas West told me that this decision will help curb Wayne County's prolific forfeiture machine and protect car owners throughout Michigan. Nobody should lose their car because they love someone with a drug problem. This decision makes it clear that those innocent people are not the targets of Michigan's forfeiture laws. If you hate spam emails as much as I do, you'll love our client Jay Fink. Here's the backstory. California makes it illegal to send certain kinds of spam. But to fight it, recipients must do a lot of work to identify, index, and prepare the messages that they want to challenge in court. That's where Jay's company comes in. They read the client's junk mail, flag the messages that might violate the law, and compile them into reports. After a lot of success, California shut Jay down because he didn't have a 6,000-hour private investigator license for reading emails. A judge just ruled that forcing Jay to get a license to run his business is so irrational that it violates the Due Process Clause of the 14th Amendment. Take that, spammers. In a huge win for property rights, the Tennessee Court of Appeals unanimously affirmed that their constitution forbids state game wardens from entering land owned by Terry Rainwaters and Hunter Hollingsworth without a warrant. For context, in a study published earlier this year, we found that the federal open fields doctrine exposes about 96% of all private land in the country, or about 1.2 billion acres, to warrantless searches by government officials. Reining in the open fields doctrine will be a long battle, but now state courts have an excellent model for how they can use their independent constitutional text to reject the federal rule. And when enough state dominoes have fallen, IJ will stand ready to take this issue into federal court, where we can end the open field doctrine once and for all. Well, that's all for today. Don't forget to subscribe and become a monthly donor at ij.org/monthly.